I'm Nigel Morris-Cotterill, and this is Financial Crime Basics from FinCrimeTV. In this episode, what is a Financial Intelligence Unit, or FIU? The concept of a Financial Intelligence Unit, known by that name, arose because that is what members of the Financial Action Task Force called it. But the concept of the function of a Financial Intelligence Unit existed long before a global brand name was invented. The function as required by the Financial Action Task Force, or FATF, is to act as a clearinghouse for information relating to suspicious transactions and for cash transaction reporting. The core function also requires that the FIU analyse the information that is provided to it. So all Financial Intelligence Units, or FIUs, do this. But some do more. It was Thailand's Anti-Money Laundering Office, or AMLO, that, so far as I'm aware, first created a combination FIU and investigation and ultimately prosecuting authority. That model has been adopted in a relatively small number of countries. Perhaps the closest is the UK's National Crime Agency, which is heavily involved in investigations and prosecutions, not only of financial crime, but of other offences such as the investigation and prosecution of child sexual abuse and related material. The significance of the National Crime Agency model is that it is the principal agency for international cooperation for transnational, that means cross-border, crime of all kinds. Other FIUs stick close to the FATF's remit in that they are passive recipients of information, which they analyse and send to relevant investigation and prosecution agencies, and of course maintain, insofar as interagency turf wars permit, databases that other agencies can interrogate. Others, especially those that are in effect embedded in a central bank, work closely with the central bank's regulatory and enforcement divisions, but are not integrated with them. One of the problems FIUs face is that every country has multiple agencies which often overlap, and they jealously protect their own cases and information. It is ironic that so much of the public sector is under a statutory obligation to feed information to the FIU, but government bodies and agencies are not under a like obligation. FIUs are constantly under financial pressure. Both computing power and competent and loyal staff are increasingly difficult to find and increasingly expensive. The demands on their resources are immense, and from time to time FIUs ask reporting entities such as banks, insurance companies, fintech companies and even car dealers and jewellers to review the standards of reports they make and to try to reduce them. This is an invitation to break the law, both at statutory and at regulatory level. The duty to submit suspicious activity reports is clearly stated. Financial institutions and others subject to the law have no choice. If there is suspicion, a report must be made. There is no protection for any business that decides not to make a report and marks the file something like, "I didn't think it was serious enough," or that the suspicion was strong enough. You can see the programme on cash transactions and suspicious activity reporting for more on this. The end result is that if governments don't fund FIUs properly, the FIUs will eventually choke on the information that governments have required businesses to send to the FIU. FIUs are often divisions of the central bank or of the Treasury because the core function is closely related to banking and so on. But some, like the UK's National Crime Agency, fall under the Home Office or similar. That's the office that's responsible for policing. Nigeria's FIU is unusual in that it falls under two supervisors, the Central Bank and the Economic and Financial Crimes Commission. The USA's FinCEN has a remit that is expanded in a very different direction. It has regulatory functions. It also maintains the registry of, for example, money services businesses, or MSBs, and at the time this programme is produced, is preparing for the USA's National Register of so-called ultimate beneficial owners of limited companies and other business structures. In general, suspicious transaction reports must be filed with the FIU and must not be notified to anyone else. In the UK in the 1990s, the solicitors regulator became extremely frustrated with lawyers who, despite clear instructions to the contrary, reported their suspicions of money laundering to what was then known for both regulatory and membership purposes as the Law Society. But even so, the position is not as clear-cut and universal as it may seem. In Singapore, banks and others are required to submit reports to the FIU, which is known as the Suspicious Transaction Reporting Office, but they must also file a copy with the financial regulator and central bank, that is the Monetary Authority of Singapore. Finally, there is a cause for confusion. Some banks have named their own department that receives and acts upon internal reports made by staff as their financial intelligence unit. To be clear, these have absolutely nothing to do with the financial intelligence unit operated by government and referred to in legislation and regulation. It is important that you do not become confused as to exactly where your reports must be sent and who is dealing with them. Your internal reports, in accordance with your company's policies and procedures manual, will be delivered to your company's money laundering, etc. risk and compliance officer. They are not sent directly to the National FIU. Thank you for watching. Don't forget to follow, like, share and of course to keep watching FinCrimeTV. I'll see you next time.